Chrissy, you got a text, and the text was saying that they have a family trust. How do they protect their assets from creditors, automobile accidents, doctors, hospitals, credit cards, you name it? And first I want to tell you is that the vast majority of trusts that you hear about out there are revocable living trusts. They are for the purpose of avoiding probate. They have nothing to do with protecting your assets from creditor claims, okay? If you have a trust for the purpose of avoiding probate, a revocable living trust, any creditor that can get your money without a living trust can get your money with a living trust. So what's our typical advice to clients like that when they ask us this question, Chrissy? Test. Here's a test for you.
Yeah, well, the test is we right away tell them that the living trust is not going to avoid it. Their best protection is to be well insured.
Yes, right on. Yes, have lots of insurance, including an umbrella policy.
Exactly. And it is a pretty common question that people do ask if I have a trust, or they think that if they have a trust that will be their best protection.
Right.
And we, of course, explain to them that being well insured is the best protection. The trust, exactly like you said, it's confirming for them, but the trust, and if you fund it, will protect you and your family from probate.
Yeah. So here's a simple step you can take if you want to help protect your assets from creditor claims. And this is for a married couple, okay? Remember that here in the state of Florida, if you're driving a car and you have a terrible automobile accident and you are underinsured, the person you can hurt can sue both the driver, you, and the owner. If you're a married couple and your cars are owned in both names, it means they can sue you both. So for that reason, here's a little something you can do that's easy, and that is the husband takes the car that he drives the most, puts it in his name only. So if he has a terrible automobile accident, they can only sue him. The wife takes the car that she drives the most, puts it in her name only. She has a terrible automobile accident, they can only sue her. Why is that important? Because here in the state of Florida, if you only sue one spouse, the husband or the wife, they cannot touch any assets that are owned jointly by the husband and wife, okay? So that in itself is a big roadblock for creditors to collect money, especially when they can only sue one, just the husband or just the wife.
Exactly.
Now, also, if you've got kids out there driving around and their cars are titled in your name and the kid's name, and kids these days, they're more likely to have accidents than us responsible adults. Correct. Well, they're driving a big liability around town with your name on it. So if you can afford it, if it makes sense to you, take the kids that drive the cars that your kids are driving, put them in your kids' names only.
Exactly. And Tom, we do tell people and consult people on this in all of our meetings with clients, and that is exactly what you just said. We suggest and recommend about keeping those cars, especially in even husband and wife, even in your individual names based upon which spouse drives which car the most. Furthermore, like you said about the kids, we have also had clients in our office that we work with that the parents have been sued because the teenage child got in an accident. Worse yet, we've had situations where the teenage child's girlfriend, boyfriend was driving the car, got in an accident, and now they're suing parent because of being on there. Pretty tough situation.